Chamber members. Thank you so much for joining us today. Today I'm speaking with Gary Wheeler, a partner with Constangy, Brooks, Smith, and Prophete in Jacksonville. Thank you so much for being here, Gary. We really appreciate your support and your ability to talk about this topic specifically of interest to our employers. The legal questions that some of our members have or may be considering with relation to the COVID-19 or coronavirus, and what they can and cannot do.
Thanks for having me, Kathy. It's a hectic, strange time for employers, and we're just happy to be able to help.
Great, thank you. So we're going to go ahead and get started with one of the first questions that we've heard and that we know people are thinking about, and that's simply, as an employer, do I have the ability, can I ask an employee to stay home if he or she is sick, or to leave work if they exhibit any symptoms of COVID-19, the coronavirus, or the flu?
Yes, you can. That's a great question that comes up a lot now. The Americans with Disabilities Act protects employees from perceived discrimination. However, it also allows employers to take precautions when they have a reason to believe that an employee presents a risk to himself, herself, or to others in the workplace. And this is certainly that occasion. And the EEOC, as late as yesterday, issued guidance on this and said that employers can do just that. They can send employees home or ask them to leave if they're exhibiting symptoms of COVID-19.
Thank you. I know that's really important and on many people's minds about keeping themselves healthy, their workplace healthy, as well as making sure that people who need to get medical care if they needed that. So another question that's come up is, can an employer take the temperature of a worker or order them to get tested for the virus?
Yes, and as late as last week, I would feel strange answering that way, but things have taken a strange turn, and the ADA does generally prohibit any kind of medical questions or examinations, and this qualifies as an examination. It's a simple examination, but we know it's a very important one under the circumstances. But generally, those are very narrow. But in this case, because we have a declared pandemic, employers do have the ability to require that employees submit to being able to take their temperature to see if it's safe to work around the workers, and particularly also in the setting where they're interacting with the public. So they can do that.
Good. So here's another one that's come up. An employee of ours has tested positive for COVID-19. What should I do?
Well, if that employee learned of the positive test at work, the employee needs to be sent home immediately. If they, notify you by phone or text or email, then, ask that employee stay home. And then, once they're away from the workplace, you'll begin an inquiry into figuring out who the employee had contact with. And here's where it gets a little difficult is, under the ADA, you need to keep the identity of the employee confidential, but we know we also need to investigate to see who they've had contact with so we can alert those employees, or, it could be independent contractors, customers that they've had contact with, for basically the last 2 weeks, and alert those people. So you put together that list and you find out the circumstances, and then you contact those people. So that would be the step that you would take.
Thank you. So this is the last question that's been posed at this moment from our members. One of our employees has a suspected but not confirmed case of COVID-19. What should we do?
That's essentially kind of this almost identical to the answer I just gave, is that, we know how difficult testing can be under these circumstances. The tests are fairly limited, and most people are being asked, if you're exhibiting those symptoms, to treat yourself as though you do have COVID-19. And, So in that case, employers would do the same. They would either ask the employee stay home or go home if they're not there, and continue. Now it might be a little bit different with the how do we handle the people that they've been in contact with. That's just a judgment call that I can't make without knowing the facts and circumstances. Whether you would require those people that they've had contact with, that's going to be a judgment call for the supervisors or the management to make based on the the level of the contact, when it happened, and how substantial that contact was. So
thank you so much for sharing this information with us and your knowledge, experience in this area of loss specifically. I'm sure there's going to be many more questions that will come up and that we'll hear from our members about. So we're hoping we can maybe pick up this conversation again in the future. But in the meantime, I just want to point out to everyone that we are conducting this conversation via Zoom, which allows us to stay where we are safely and keep our social distance. Here at the Chamber, we're practicing that with some of our members working from home, some of our staff members working from home. Those of us who are in the office are keeping our social distancing and being very careful so that we don't cause any, continuation of the problem, but rather are part of the solution. So we appreciate, again, the information that you're able to share with us so that we can help our members answer those questions and be prepared and keep their workplaces safe as well.
Thank you, Kathy. Thanks for having me on.